Welcome to Law Camp YouTube channel. I thank you for the continuous support given by the viewers, especially to the law students and the public. I am Advocate Ravi Kumar, the lecturer and the law researcher. In Law Camp videos, I every time discuss about the most important topic that are useful to the public and explain the topic with the related provision of law, and obviously that help you to overcome from the hardship with a quick remedy. As if today the topic, how do you defend your property from the bank recovery process? What are the courts and tribunals and related provisions of law that secure you from the exorbitant penal interest, penalties, and gaining you a sufficient time for paying the debts? Whom you should contact, when you should contact, how to deal it? I try to explain the matter little bit briefly in this video. Most of the people think that the debt recovery tribunals are only hearing the bank side and taking action against the borrowers, and felt absolutely insecure. Therefore, many of the people surrender to the bank unconditionally and pray for sufficient time for paying their debts, even agreeing to pay the principal amount with a huge interest along with the all penalties. When the bank manager is communicating with you on one side, the legal wing will be sending a SARFAESI notice in the another side. If you ask the bank what is the necessity of the legal notices, the bank used to respond to ignore those notices, convincing you for a one-time settlement. When you trust them and not taking any legal defense, they unleash the recovery proceedings and taking the possession of your property. Bank knows when to launch the recovery action against you, but you don't. The borrowers are completely vulnerable and cornered to pay the debt within the very short period of time, along with the huge interest. The borrowers went through enormous mental stress and subject to various harassment, and finally end up in losing their money and sometimes losing their property. Bank can initiate their recovery process not only in the debt recovery tribunal but also in the chief metropolitan magistrate and judicial magistrate courts. When bank is desiring to initiate the recovery process, they are serving you the notice under 13 subsection 2 of SARFAESI Act. In the aforesaid notice, they usually classified your account as non-performing asset and demanding you to pay the full debt within the specified time, normally 60 to 90 days. When you are not paying the money within the specified time, you will be served with 13 subsection 4 of SARFAESI notice for possession, and ultimately bank is in complete advancement for taking the possession. When you are receiving a notice under 13 subsection 4 of SARFAESI Act, you should rush to the debt recovery tribunal immediately without any further delay. You should file your petition under section 17 subsection 1 of SARFAESI Act immediately, along with the interim petition for stay the recovery proceeding. You make sure that your petition will with all the facts, all the case merits with suitable grounds, than copying some grounds from the another DRT application. You should consider in filing an interim application for waiver of huge interest by referring the RBI guidelines in the recovery proceeding. Hence, you can make your application can be heard very precisely in the tribunal, and you may get a better relief. If you are not contesting the case, bank get the favor orders from the DRT and file their petition under section 14 of SARFAESI Act for taking possession of your property. The bank may appoint an advocate commissioner through the court and advancing the recovery process for obtaining the physical possession. The provision in 13 subsection 7 SARFAESI Act allows the bank to recover the entire cost, charges, and all expenses from the borrower. The SARFAESI Act, the scrutinization and reconstruction of financial asset and enforcement of security interest act under section 13, under section 14, no matter what, you are still able to protect your property and defend your family. All you require is an advocate who has a better experience in handling the DRT cases and some good knowledge in High Court writs, whom you can rely for obtaining sufficient time for paying the debt and possible interest waiver. When you are filing a case against the bank, your application is classified under SA number. When the bank already initiated a case against you, it will be numbered as OA, that is original application. Whatsoever, you have to ensure your petition filed with interim application for stay the proceeding and the right time, and DRT usually grant the stay against the recovery proceeding with some conditions. Make sure that you comply those conditions within the specified time and submit a memo in DRT that you have complied the order and obtained the permanent stay. Otherwise, DRT may not aware that you have complied the conditional order and dismiss your petition. Any small ignorance at your side may end up in advantage to the bank, so please be careful. DRT is a tribunal and they usually not required to follow the civil procedure code like honorable courts. DRT nature in expeditiously adjudicating the matters and taking comprehensive decisions and passing orders that may favor to the bank most of the time. DRT may overlook the principle of natural justice and passing orders where you can challenge those orders and decision in the appropriate high courts. There were thousands and thousands of writ petitions recorded in the High Court that where DRT acted against the principle of natural justice, and Honorable High Court has heard the appropriate petitions and has passed orders by setting aside quashing the DRT impinged orders. There are thousands of case laws you can find in the related legal virtual sites. Also, you have to remember DRT is completely a tribunal and not a court, and you should aware that any small ignorance of your side will be highly advantage to the opposition bank. As told earlier, commonly DRT is an appellate tribunal for the DRT. That mean to say DRAT is the complete appellate tribunal for a DRT. DRT Chennai is an appellate authority for all south regions, that including DRT 1 Chennai, DRT 2 Chennai, DRT 3 Chennai, DRT 1 Bangalore, DRT 2 Bangalore, DRT 1 Ernakulam, DRT 2 Ernakulam, DRT Coimbatore and DRT Madurai. No matter what stage is the recovery, that is symbolic possession, physical possession, auction, sale, you can defend your property in appropriate tribunals and apex courts and obtain the stay proceeding and obtain sufficient time and get rid of the unethical penal interest. All you have to do is believe in the process of law and not believing the oral promises of a bank or any private person. The purpose of video is to assist you in the critical stage and guiding you with the appropriate remedies during the recovery process. I hope my video is very helpful, and you can post your comments, and I really try to reply at the earliest, and I try to post some of the videos about DRT, DRAT and SARFAESI Act proceedings in upcoming videos. Thank you so much. This is Advocate Ravi Kumar.